Hi everyone, welcome to our webinar, CO2 Pipelines, Siting and Safety, Environmental and Economic Regulations. I am Ryan Frome-Pizzulli, Program Manager of the Institute for Energy Law, which is an institute of the Center for American and International Law. This webinar is hosted by IEL's Academic Outreach Committee, and this is the second of two sessions we have planned on energy transition academic topics. I would now like to welcome our three speakers. We have Scarlett Forrest, Madeleine Lewis, and Tara Righetti. Scarlett is a licensed attorney and jurisprudence underground law and energy, or JOULE, research scientist at the University of Wyoming School of Energy Resources, where she studies the laws and policies impacting natural resources, energy, and infrastructure development. Next, we have Madeleine, an associate research scientist and lecturer at the University of Wyoming School of Energy Resources, specializing in energy-related legal scholarship in the JOULE Research Group. And last, we have Tara Righetti. She is a professor in the College of Law and the Occidental Chair of Energy and Environmental Policies at the University of Wyoming, where she serves as the director of the JOULE Research Group and as co-director of the Nuclear Energy Research Center. I'll now pass it over to our speakers.
Thank you for that introduction, Ryan. Just checking you can still hear us. We're going to say yes. Today, the three members of our team, the Jurisprudence of Underground Law and Energy, our clever little acronym for our research group here at the University of Wyoming School of Energy Resources. We will be leading you through the exciting world of CO2 pipelines, covering topics including siting, safety, and environmental and economic regulation. Can I just click this? Okay, so a quick roadmap for you. At first, we'll give an acknowledgement, and of course, because we're attorneys, we'll give disclaimers. Background, we'll cover a little bit of the history of CO2 pipelines in the US and what the current network of pipelines looks like. Professor Righetti will be covering siting of CO2 pipelines, including things like route considerations, state siting processes, issues of public use and protest. Scarlett will cover pipeline safety and environmental regulation, taking us through various laws that are really relevant to those safety and environmental aspects. And then Tara and I will cover economic regulation of CO2 pipelines, which is a field that we both find really interesting. We could talk about it for a while. We have an article forthcoming in the Oil, Natural Gas, and Energy Law Journal in Oklahoma that we hope you'll all look out for in the near future. But I'll get us started. Just to acknowledge, some of this material is, it's been supported by an award from the U.S. Department of Energy. However, it does not represent, nothing we say in this presentation necessarily represents the views of the Department of Energy or any other agency of the U.S. government. Nor does this presentation constitute legal advice or establish any type of attorney-client relationship. All right, so CO2 pipelines in the United States. How do I get this to? I'm not sure. Currently, we have about 5,300 miles of CO2 pipelines in the US right now. I have these two depictions side by side from 2007 to 2025. The idea there is that you can see it hasn't changed much in the past 2 decades. Over the last 50 years or so, the network of pipelines that we have has developed primarily in relation to enhanced oil recovery operations, which means that the network is really highly localized in areas with a lot of EOR. Like, you can see some concentration there in the Permian Basin or the Gulf Coast, a few in Wyoming and Oklahoma. Unlike pipelines for natural gas, which cover an expansive area across the entire country with a lot of long-haul transport, CO2 pipelines are often used to transport CO2 from a private facility where an entity produces CO2 and then transports it to an oil field that's been depleted for its own use in EOR. So it looks a little bit different, but just for context, it's only about, I think ClearPath reported recently that it's only 1 to 3% of the length of our existing 3 million miles of oil and gas pipelines in the US. So it comes with different considerations all around, which we'll talk about. So currently, drivers of CO2 transport demand and construction incentives, this is a big deal. I'm sure many people on this call are already familiar with the provisions of Section 45Q of the Internal Revenue Code, just call it Section 45Q, which awards tax credits for every ton of CO2 that is captured from an emission source and either permanently stored or used in operations such as EOR, for instance. 45Q was initially passed in 2008, and it's gone through various iterations through the years. Currently, there's a maximum credit available on the sequestration side of $85 a ton, which came out in the bipartisan infrastructure law in 2022, intended to incentivize permanent storage of CO2 for climate-related purposes. That $85 per ton, we say it's a maximum because to reach that full amount, there are certain apprenticeship and labor requirements that need to be met. But 45Q also covers enhanced oil recovery and incentives for EOR. So very recently, the One Big Beautiful Bill Act enhanced a previous level of the Section 45Q credit that was lower than the credit available for pure storage. So it went from $60 per ton to $85 per ton that's used, trying to seek parity with that credit available for sequestration. In Wyoming, the language used around that idea that there should be parity between credits available for sequestration and EOR is kind of leveling the playing field. It's also an issue that has been taken up by state legislatures, including in Wyoming. Finally, one last incentive that is important to discuss is the Carbon Dioxide Transportation Infrastructure Finance and Innovation Act, otherwise known as CIFIA, which is a DOE-administered federal loan assistance program. It supports common carrier CO2 pipelines, but also supports other types of transportation, such as by rail or truck for CO2. In addition to providing federal loan assistance, it also created a future growth grant that will provide financial assistance for designing, developing, and building CO2 transport systems in instances where the capacity of the pipeline you want to build exceeds CO2 volumes currently under commercial contract. So what that means is currently, if you don't have the contracts to support the size of pipeline that you want to build, but you foresee as being necessary, you can find funding to build that excess capacity still up front. Interestingly, in the first round of funding for the CIFIA program, I think there was only one letter of inquiry that was actually submitted. It's not completely clear to us why there haven't been more takers. There was another round of funding opened up in December for $500 million. I think that there's some challenges I'll talk about on a few slides here, but some of the challenges are, of course, not a clear demand signal for CCS. The Section 45Q credit will phase out automatically in 2033 now. And capture facilities are still really in development. They are expensive and still reaching that commercialization phase. But what this means, as long as we still consider CCS to be a driver in the future of CO2 pipeline transport demand, unlike that localized network that is developed primarily for EOR, now we're looking at the need for a national network that can collect CO2 from point sources across the United States and take them to storage basins that aren't necessarily co-located with the vicinity of the point source, but this translates to a need for longer pipelines. This is from Princeton's Net Zero America study from 2021. There were several scenarios contemplated. This is just one of them. But in general, you can see that there are longer pipelines than we currently have, an emphasis on trunk lines with high capacity, and overall expanding outside of the Permian and Gulf Coast region where we've traditionally seen these pipelines. Challenges. Of course, the elephant in the room is the high capital cost of constructing large infrastructure. That's no secret. And CO2 pipelines pose some specific challenges because CO2, when it's transported, there are issues of corrosion. If there are impurities of any kind, that can be a problem. Embrittlement of pipelines can result if there are, really any impurities. At the same time, the pipelines that we want to build, the most valuable type of pipelines, are going to be these large, eventually more efficient shared capacity pipelines that are on a regional scale and, again, less localized than we've seen for EOR. But of course, that takes a lot of negotiation of offtake agreements and getting that CO2 capacity where it needs to be. Like I noted, there's a lack of consistent demand signal, particularly with the change of administrations. A lot of the other tax credits under Section 45 of the Internal Revenue Code those for other types of energy infrastructure have been cut short or reduced recently. It seems like 45Q is still here to stay, but in any event, it'll still expire, and we're still looking for that capture equipment to become more commercialized. And then, as we'll talk about as well, I think Tara will get into this a little bit more, but the potential for conflicting state rules. How do different states work together to build this regional infrastructure that ultimately serves the needs of CCS projects?
So I'm going to talk now a bit about routing and siting CO2 pipelines. There's really two different issues. One is, how do you decide where to build the CO2 pipeline, which is a combination of technical and legal factors. And so routing considerations usually go according to a multiple decision factor model and would incorporate things like safety, where you would look at geohazards, land use, population density, environmental factors like wildlife, habitat, wetlands, and efficiency for topography and distance and your right-of-way acquisition costs, things like land fragmentation. Those all come into the way that the pipeline developer is going to determine where the pipeline needs to be built in order to connect sources of CO2, which can be both natural sources that occur geologically, like those at the Jackson Dome in Mississippi, or the McElmo or Bravo domes in Colorado and New Mexico, where most CO2 is produced from right now, and then also connecting into anthropogenic sources as they install capture equipment or are separating CO2. Right now, the primary sources that are being that are economic under the current 45Q credit would be gas separation facilities and ethanol facilities. And so, as Maddie illustrated, you have to find a way to link those sources to potential carbon sinks, whether those are EOR projects or geologic saline storage. So the map you see here is from the University of Iowa Hubble Environmental Law initiative, and as part of the Iowa Carbon Pipeline Map project. If Iowa is of interest to you, it's a fantastic resource. And you can see here the 3 different pipelines that have been proposed through the state of Iowa, and all of the different counties that are in blue are the counties that would have some segment of CO2 pipeline proposed within it. So the way that siting actually happens from a legal authorization standpoint differs on a state-by-state basis. So FERC has disclaimed jurisdiction over CO2 pipelines. There's a FERC order where they had looked at a stream of gas that was 98% CO2 and said this is not natural gas as intended in the Natural Gas Act. So we don't have federal siting authority in the same way that you would cite natural gas pipelines. And so as a result, they're cited under state law. There's really three buckets you could put these in. The first are the states that have centralized siting processes. Iowa, South Dakota, and Louisiana are examples of those. And so in a centralized process, the routing has to be approved by a state agency. In Iowa, it's the Iowa's Utilities Commission. It differs obviously from state to state. And that group, that agency would look at the proposed route and grant a permit to construct a hazardous liquid pipeline. As Scarlett will talk about more, CO2 pipelines fall into the category of hazardous liquids pipelines, not because CO2 per se is hazardous, but because the transport of it presents certain hazards that need to be managed. County ordinances and other sort of local government rules may still apply even where you have a centralized process, because there may not be sort of complete field preemption there. In a decentralized process, which is what exists in Wyoming and Nebraska, there's no statewide agency responsible for Wyoming. So, for example, the Wyoming Public Service Commission, which is responsible for routing natural gas pipelines, intrastate natural gas pipelines, has said that they don't regulate CO2 pipelines because CO2 pipelines are not serving the public. They're only serving to carry offtake between EOR facilities or storage facilities, these large industrial users. And so they have said that they will not be regulating under their authority. This means that routing decisions are primarily made by the pipeline developer, but could be constrained by local government regulations. But you may not actually have really a statewide look at it at all unless the developer seeks to use eminent domain. The third category, which I don't have shown here, is actually the majority of states. And those are states that have no specific laws related to CO2 pipelines at all. And so they may have other rules giving administrative authority for siting pipelines for oil or natural gas pipelines, interstate natural gas pipelines or oil pipelines, and really to see how you would develop a CO2 pipeline in that area is going to require looking at those rules and seeing if they would or may apply. The primary area of involvement and the primary area of contestation for CO2 pipelines is around the use of eminent domain. So whether there's a right of condemnation is determined by state law and requires a showing of public purpose. This is the really big sticking point, is whether CO2 pipelines serve a public purpose. Some states would look at CO2 pipelines as serving a purpose if used for EOR, but not if used for decarbonization. And other states may take the completely opposite position, depending on sort of state politics and the natural resources that exist in those states. Some states, like Wyoming, also include a public use requirement, which could be statutory or constitutional. And then some states have banned use of eminent domain for CO2 pipelines completely. So South Dakota statute passed last year, I believe, bans use of eminent domain. The Iowa legislature earlier this year passed legislation banning eminent domain for CO2 pipelines, but that was then vetoed by the governor in June of 2025. And while there's been a proposal to try to override that veto, that hasn't happened yet. The IOGCC model rules that were recently released recommend that states should authorize eminent domain for CO2 pipelines as having a public purpose, and that they should require for any pipeline exercising eminent domain that they be operated as common carriers. My personal opinion on this is that distinguishing between EOR and CO2 storage in terms of making your public purpose is very problematic, because that could potentially complicate or preclude commingled CO2 pipelines that could be diverted and then delivering CO2 for multiple different uses. So I think that would create problems and is not good policy. Eminent domain has also resulted in a lot of protest around this question of public use. And I think at the core, or sort of at the heart of this, what's animating these protests is the idea that there isn't this natural market for CO2. It's not something that we use like electricity or that we use like natural gas. And so should the government be authorizing use of eminent domain to transfer private property from one private entity to another to allow that entity then to build a project to claim federal tax credits? And so when there's not support for the federal tax credits among everybody, and maybe not a consensus from a policy perspective that decarbonization is universally needed, I think residents and landowners are having a difficult time seeing what is this public purpose that's being served. Where is the economic development goal that should, sort of override their interests in maintaining private property and in liberal contracting. So there's a lot of litigation on this, hundreds of cases actually, a lot of them in South Dakota and Iowa, but not exclusively. I've just listed 3 of them here. One upheld the constitutionality of a statute granting pre-condemnation survey access. Another granted a preliminary injunction blocking enforcement of a local ordinance, saying that part of it was probably preempted. And then the third one, which was is more than a decade old now in Wyoming, was for an EOR pipeline for CO2, and it was on the question of fair market value. And so Justice Kite in that case said that they could look at evidence of comparable easements, including natural gas easements, for the purposes of establishing fair market value, and that that could include annualized or volumetric payments in addition to a one-time payment for the taking of the easement. A last thing in terms of looking at routing, something that's come up a lot is, could we just convert the methane natural gas pipelines that we have now to CO2 pipelines, and then we don't have to obtain new right-of-ways? First, I'm going to say that I think the potential of that is overestimated for a couple different reasons. First, CO2 transport has its own technical requirements, and those technical requirements, existing natural gas pipelines may not be compatible, at least with supercritical phase CO2 transport in all cases. The second issue is that the pipelines for natural gas are not necessarily going in the same places that you would need CO2 pipelines to go. And the third, which I think is the biggest one, is that most of our natural gas pipelines in the US are still in use and are going to be in use for a long time. And there's a whole bunch of problems with discontinuing use for those prematurely. So that doesn't mean it can't happen, though, and Tallgrass, with their Trailblazer pipeline, recently did go through this process. And so it involved really several steps. The first was to discontinue use for natural gas, and then obtain a FERC abandonment for natural gas service. Then there had to be a number of different modifications, upgrades, to decommission some of equipment, bring this whole system up to PHMSA standards for hazardous liquid pipelines, amending any landowner easements agreements where required to make it clear that that CO2 transport was okay, and then also obtaining new offtake agreements so that there was commercial contracts for transport of CO2. So I think in some limited situations this might be a possibility, but not universally. So with that, I'm turning it over to Scarlett.
Does that mouse work? Or should
I was just using the arrows.
Okay, perfect. Well, as Tara just said, I'm Scarlett, and I will be covering the safety and environmental regulatory portion of this presentation. So I wanted to just start with what are the safety risks. The main liability of concern are pipeline ruptures and leaks. And while carbon dioxide is not flammable nor combustible, it is denser than air, and it can displace oxygen and create an asphyxiation risk. And then another safety issue is coming into direct contact with supercritical carbon dioxide that are in the pipelines, which can cause cause cold burns or frostbite. And with supercritical CO2, it's kind of this compressed state where basically you can kind of picture dry ice for supercritical CO2. And then the picture to the right is of the most significant carbon dioxide pipeline safety incident in the United States. And it was in Satartia, Mississippi. And what happened was after this pipeline burst or broke, Satartia residents experienced symptoms including mild narcotic and transient effects, headaches, and loss of consciousness. And while some residents were treated at the hospital and then released, this did not result in any reportable injuries under PHMSA incident classification standards, because PHMSA defines a reportable injury as one that necessitates overnight hospitalization. So going into, not just mine, going into pipeline safety regulation, our statute is the Hazardous Liquid Pipeline Safety Act of 1979, as Tara mentioned. PHMSA, which is the Pipeline and Hazardous Material Safety Administration, for those that don't know, is housed underneath the U.S. Department of Transportation, and they regulate pipeline safety through the Office of Pipeline Safety. We do want to highlight that PHMSA does not issue permits. PHMSA instead maintains contact with pipeline construction and operation activity and uses its rulemaking authority to set and enforce safety standards. And it does this by conducting programmatic inspections of management systems and procedures, and then inspecting facilities and the construction itself, and investigating safety incidents, and etc. No.
Oh, sorry. I'm going to close that for it to go forward. Okay. Nope. Sorry.
There we go. And so PHMSA regulations only cover pipelines transporting carbon dioxide in this supercritical state, so that kind of dry ice state, which means that 90% of the molecules in the CO2 stream are compressed into a dense supercritical state. And then PHMSA rules governing pipelines transporting carbon dioxide in a gaseous phase are expected to be regulated under different PHMSA rules that have yet to be promulgated. So there is a gap in the federal framework for gaseous state carbon dioxide. And then PHMSA has announced a rulemaking to update safety standards for carbon dioxide pipelines following that incident in Satartia, Mississippi. And that announcement came out in May 2022. And PHMSA commenced rulemaking during the final days of the Biden administration that would impose not just safety requirements, including emergency preparedness, but also establish new standards for transporting carbon dioxide in a gaseous state. And when the Trump administration took over shortly afterwards, this rule has not been published in the Federal Register and can be assumed to be withdrawn pending review. Oh, thank you. And federal laws allow for state pipeline safety programs pursuant to the statutory provisions on this slide. States may obtain a certification every year from the Office of Pipeline Safety to regulate safety of intrastate pipelines. This state certification indicates that states assume intrastate regulatory, inspection, and enforcement responsibilities. To participate in the PHMSA pipeline safety program, states must adopt the minimum federal pipeline safety regulations, but may enact more stringent safety standards. And states must also provide for enforcement sanctions that are substantially the same as those authorized by the pipeline safety statutes. PHMSA annually reimburses states for operating these programs up to 80% of the total cost of those activities reasonably required to conduct the safety program, and it does this through grants. A state agency which that doesn't satisfy the minimum criteria for obtaining a certification can also get can enter an agreement with PHMSA where they still conduct inspections and ascertain compliance of pipelines within the state, But any probable violations are reported to PHMSA, and they are responsible for the enforcement action. PHMSA also may authorize a state to act as its agent to inspect interstate pipelines. However, the federal government still retains responsibility for enforcing those regulations. And then as an example of a state pipeline law that we found pretty interesting is California's 2022 bill that they passed that prohibits intrastate carbon dioxide pipelines until PHMSA updates its rules, which only allows intra-facility carbon dioxide pipelines. So that those PHMSA rules that have kind of been pending since January of this year, California is waiting for those to actually go into effect before allowing intrastate carbon dioxide pipelines. So next, I'm going to discuss the environmental regulations, and those are pursuant to the Clean Water Act, Section 404 permitting, and NEPA. Section 404 of the Clean Water Act requires a permit to discharge dredged and filled material into waters of the United States, which are navigable waters that have been susceptible or that have been or may be susceptible for interstate commerce, including waters that are subject to ebb and flow of the tide. And this includes wetlands with a continuous surface connection to a navigable water, and then Section 10 of the Rivers and Harbors Act, which is all kind of under the same umbrella. Also applies to construction activities impacting these waters. This program is also administered by the U.S. Army Corps of Engineers. And when you go for one of these permits, they can fall into two classes. They're nationwide general permits and individual permits. With the nationwide permits, with the general permits, they authorize broad categories of activities that have been found to have minimal cumulative impacts. And individual permits are required for projects that exceed minimal cumulative impacts or impact a specific wetland or a specific water body. And in the next slide, I'll get a little bit more into kind of the difference between the two. For the permitting criteria, you need to show that there's no practicable alternative that is less damaging to the aquatic environment than discharging dredge and fill material. There needs to be no significant adverse impacts to waters of the United States, appropriate and practicable mitigation of potential impacts, which basically indicates that you have taken steps to avoid impacts to wetlands in these water bodies and that the potential impacts have been minimized. But also compensation must be provided for unavoidable impacts. And then also you may not violate any other state and federal laws. And so specifically for carbon dioxide pipelines, the general nationwide permit 58 is where you can receive a general permit for your carbon dioxide pipeline. And this is provided that the activity does not result in the loss of greater than a half acre of waters of the United States for each single and complete project. If the project results in more than minimal individual and cumulative adverse impacts and cannot meet the standards of nationwide permit 58, does not qualify as a single and complete linear project, which is the next bullet definition, or the chief of engineers can just assert his or her discretion and require an individual permit, then you do need an individual permit, and the nationwide permit is not sufficient in and of itself. And so this definition of these single and complete projects are kind of about how many times you cross these water bodies and interact with these water bodies. So crossing a single water body more than one time at separate and distinct locations, or multiple water bodies at separate and distinct locations, each individual crossing is considered a single and complete project for the purposes of being authorized under the nationwide permit. And then the next environmental law I want to talk about is the National Environmental Policy Act, or NEPA. As most people probably know, NEPA processes and the CEQ's regulatory authority are kind of unclear and in flux. There were 2 court cases and Trump administration policies and executive orders that essentially removed the Council of Environmental Qualities, which is the executive agency who implements NEPA. So it took away their rulemaking authority, or at least specifically CEQ issued an interim final rule that removes their regulations. And so this does kind of leave questions for how these processes will go forward, but I'm kind of just going to explain what the status quo was up until this point. But basically, the Army Corps of Engineers NEPA regulations incorporate the rescinded regulations, CEQ's rescinded regulations by reference. So that's kind of where that confusion stems from, or not confusion, but uncertainty stems from. So the Clean Water Act triggers NEPA review because it's considered a major federal action significantly affecting the quality of the human environment. It's a procedural statute only, and it does not require agencies to take the most environmentally protective action. And there are these levels of NEPA review that the Army Corps of Engineers determines in consultation with CEQ. And those are your category exclusions and the categorical exclusions, which are categories of actions that normally do not have significant effects on the environment and no further environmental analysis is required. Then there's the environmental assessment step, which is increases the level of analysis and reporting. And it discusses the purposes and need of the action, of the proposed action, potential alternatives. The proposed action in this case would be whether or not to grant the 404 permit, and then assesses whether more environmental analysis is needed. And that's when you have your environmental impact statement. Before these recent changes to CEQ and their regulatory authority, most of the time, carbon dioxide pipelines would trigger the most analysis under the environmental impact statement. And then I just wanted to briefly cover some other laws that might apply, but that depends on the specifics of your project. There's Section 7 of the Endangered Species Act, where consultation with Fish and Wildlife Service is required if the pipeline construction or operation may affect a listed species or critical habitat of a listed species. Then there is the National Historic Preservation Act, where the construction and operation of the pipeline could cause impacts to properties that are listed in the National Register of Historic Places. And then there's also Section 101 of the Clean Water Act, where, but this part is only relevant if the state, tribe, or the EPA itself, whatever the relevant water quality authority is for the jurisdiction you're putting your CO2 pipeline in, has not previously certified compliance of their water quality program with the nationwide permit 58. And what's also interesting about Section 101 is this implicates state laws and then state law environmental regulation, because Section 404 requires that all applicants applying for a permit to provide certification from the water quality authority in which the discharge originates or will originate, that it will comply with the standards of the Clean Water Act.
All right, thanks, Scarlett. We'll shift gears here talking about economic regulation of CO2 pipelines. Primarily, this occurs through common carrier requirements. And as Professor Righetti already mentioned, common carrier requirements and that status of being a common carrier is really relevant to siting. So that's one reason that we care, but it's also about access and making sure that there's actually access to the systems that are being built, that we are able to ensure large capacities in the large long-haul pipelines that we need. So common carrier requirements in general, if you're not familiar with the term, it's just a term for any set of framework or any framework of rules or laws that will obligate certain providers of typically public services to offer their services at rates that are fair and reasonable, on an equitable basis and without discrimination as to who the customer is, as long as for CO2, transport will look at whether the shipper is actually qualified. So common carrier requirements are not specific to CO2 pipelines, of course, or pipelines in general. They can apply to any types of public good or service like utilities, telecommunications, and airlines. The class of services and goods to which common carrier requirements typically apply are those that are affected with the public interest. That's a standard that we got from a U.S. Supreme Court case in 1877 called Illinois versus Munn, which concerned the state's regulation of grain elevator rates. And so why do they matter? Again, that's the public interest standard. These are services in which the public has a vested interest in having open and equal access to. They can also prevent monopolistic behavior around large and expensive pieces of infrastructure. So a classic example is with oil pipelines and the Standard Oil Company in the late 1800s. And if you're the first come to build a large, expensive piece of infrastructure, it's typically more efficient for a single carrier to serve an entire region, which means that you can set your own terms. So common carriage, again, is important there because it dictates certain standards for rates to be equitable and prevent monopolistic behavior. How do they do that? Typically, you should look at specific statutes, but there will be a requirement to publish standard tariffs or fee schedules with a regulatory body that are transparent and public. Adhere to non-discrimination rules, meaning that you'll serve all qualified shippers equally without discrimination. Qualified, of course, means that for CO2 pipelines, for instance, if there's a shipper of CO2 that their CO2 has a bunch of impurities, maybe they're not qualified under the regulations or statute. And then also operate under public oversight. That's another hallmark of common carriage requirements. So you'll see typically utility commissions overseeing the tariff and rate process and rate making in states at the state level. So in Wyoming, for instance, our Public Service Commission does not actually have jurisdiction over CO2 pipelines for economic regulation purposes, but they would oversee the rate-making process for every other public utility. So monopoly concerns for CO2 transport. Pipelines are considered a natural monopoly. That's because they are expensive. There's a natural preference for the incumbent, so the first market entrant is going to be an advantage for any competitors to come along. The costs of completing and constructing a network are just so high, and the marginal cost for the incumbent to come in is so low that it effectively bars potential competitors from entering the market. Again, the Standard Oil monopoly of the late 1800s and early 1900s is a great example. So typically it's just more efficient for one entity to serve an entire region. So CO2 pipelines have a monopoly problem because pipeline operators can control market access and dictate prices just because it is that large, expensive infrastructure. On the other side of the scenario, though, there's maybe the inverse, you could call it, of monopoly, which is monopsony, which means there's a single buyer who's typically going to be the storage hub operator. And in this case, the operator can pay unreasonably low rates to landowners for pore space storage without market competition necessarily. And if the pipeline company is also the storage operator, which is a model that we've seen quite a bit in up-and-coming CCS projects, the monopsonist is also the monopolist, meaning they can pay non-competitive prices for pore space and also charge non-competitive prices for storage, and restrict transport access as well. So we'll take you through a couple states' common carriage regulations as relevant to CO2 pipelines. Texas is a good example because there's a case that considered this issue in depth. So in Texas, like Montana and North Dakota, which I'll talk about on the next slide, the power to use eminent domain for CO2 pipeline siting is tied to common carrier status pretty explicitly. So under the Texas Natural Resources Code, a pipeline owner or operator that is transporting carbon dioxide, this term to or for the public for hire, can become a common carrier if it files a written acceptance of certain terms with the Railroad Commission in which it agrees to publish tariffs and serve customers other than the pipeline owner. To do this, to accept common carrier status, an entity typically files something called a T4 form, in which you check a box, but we're going to interrogate that phrase a little bit. So in 2017, the case of Texas Rice Land Partners versus Denbury Green Pipeline, the Texas Supreme Court actually held that in a case where an operator did just check that box, but there was no reasonable probability of serving a future customer other than the pipeline owner itself, that wasn't sufficient. Just to check the box without actually proving that there was a likelihood of serving someone else. In that case, Denbury had sought to build a pipeline for EOR and use eminent domain. So when that entity, though, or when Denbury asserted without proof that it would operate as a common carrier, that's where we get this standard of reasonable probability. They said that simply wasn't enough. If there are complaints, those are heard and enforced by the Texas Railroad Commission. So a little bit different. So whereas Texas says, okay, if you elect to serve as a common carrier and there's a reasonable probability that you will actually serve customers or shippers other than the pipeline owner, great, you can have this eminent domain authority. In Montana and North Dakota, they take a slightly different approach, but somewhat to the same effect. So in Montana, they, through some 2009 amendments to the Montana Code, they explicitly declared that the transport of carbon dioxide is a business that is affected with the public interest. So bringing in that standard from the grain elevator case of 1877. So if it's affected with the public interest, I'm not sure, did you mention, have we talked much about Kilo yet? So a case that I'm sure everyone is familiar with, but Kilo versus City of New London resulted in many states coming out with constitutional amendments that say private property cannot be taken for private uses. So by saying it's a public interest, though, it opens up eminent domain authority, but it also automatically in Montana, any pipeline or any entity that is in the business of purchasing or selling carbon dioxide or transporting carbon dioxide is deemed automatically to be a common carrier. So unlike in Texas, it is automatic and mandatory, and there's not that elective status. In North Dakota, similarly, common carriers are permitted to exercise eminent domain, and any any pipeline that is open to or for the public for hire, or an entity that is engaged in the business of transporting CO2, it's pretty broad, will be deemed a common carrier. So there may be limited situations where it's an entirely private, closed pipeline system in which there's no requirement to operate as a common carrier. But for the most part, we read the definition as being extremely broad and encompassing almost the entire field of CO2 pipeline transport. Another example, of course, we have to talk about Wyoming. The way our statute is written and the way it reads and is interpreted alongside our Constitution is kind of interesting. So in Wyoming, we do not have any express common carrier requirement that CO2 pipelines must operate as common carriers. We do say that pipelines, any type of pipeline, has the right of condemnation. And then we allow condemnation for public use or when it's necessary for a private way of necessity. What that term means is kind of unclear. If it is a way of necessity to route a pipeline, particularly one that may cross the entire state, how do you show that that's necessarily the only way? It seems like this provision has been used for eminent domain in relation to EOR purposes in the past, but EOR under Wyoming law is treated differently for eminent domain purposes. It already has that public use consideration kind of implied in the in our Constitution under rules that have just historically promoted the production of oil and gas. So it's not clear. We're looking forward to seeing how this plays out in Wyoming, as we're sure it will. Our only case so far has dealt with issues of compensation. So yeah, some case law to watch if you're at all interested in doing work in Wyoming. Finally, before I pass it back to Tara, just to touch on some of the provisions of the IOGCC model statutes that she already mentioned. In May of 2025, the Interstate Oil and Gas Compact Commission released some model statutes that generally align more with North Dakota and Montana statutes. Like Montana, there would be an express declaration of a public purpose. So the model statute provides that, yes, CO2 transport is in the public purpose, therefore serves a public use for purposes of eminent domain and state kilo provisions. Common carrier status is automatic, similar to both North Dakota and Montana. I think it mirrors North Dakota's language a little bit more, but and then eminent domain authority is explicitly tied to that common carriage status. So it kind of closes the loop there. It has a public use, but also necessarily they'll be serving as a common carrier, and so necessarily there will be eminent domain authority implied. All right,
Okay,
Tara.
I'm going to try to go through this quickly because I want to make sure we can look at questions. Under federal law, common carrier requirements could potentially arise in two different places. The first is under the Interstate Commerce Act, and the second one is under the Mineral Leasing Act. And so when we look at here, the Interstate Commerce Act includes provisions, says the Surface Transportation Board has jurisdiction over transportation by pipeline when transporting a commodity other than water, gas, or oil. As I mentioned before, FERC has said CO2 is not gas within their jurisdiction. And so it's possible the Surface Transportation Board has jurisdiction and the common carrier provisions within the Interstate Commerce Act could be applied to CO2 pipelines. There's some Government Accountability Office reports that treat the Surface Transportation Board as having jurisdiction over CO2 pipelines, but it hasn't ever intervened. The requirements are very similar to what Maddie described in state law and as a general sort of premise of common carriers. What's interesting, though, is that the Interstate Commerce Act only applies to pipeline carriers who are offering services to the public for hire. And so a pipeline carrier who's only carrying its own CO2, for example, for storage and is an integrated, a sort of vertically integrated company would not be required to operate as a common carrier, even if the STB rules applied. I think the reason that we don't know if STB rules apply is because it will only intervene upon complaint. And so for that to happen, that means that a potential shipper of CO2 has to make a demand on the company for them to ship CO2. The company has to deny the right of shipment or offer shipment on unreasonable rates. And then either a government agency or the person who's been denied shipment would have to initiate the complaint process. And from our research, we just couldn't see that had ever happened yet. So it hasn't had, to our knowledge, an opportunity to weigh in on its jurisdiction, and it hasn't done so on an advisory basis. The Mineral Leasing Act right-of-ways that are granted under 30 USC section 185 also require the recipient of a federal right-of-way for CO2 pipelines issued under the statute to operate as a common carrier. The justification there is that if you were getting a right-of-way, for example, for an oil pipeline or a natural gas pipeline, or if you're producing CO2 from federal lands and then building a pipeline, that you couldn't deny shipment to other producers, particularly other producers from federal lands. Now, the MLA isn't the only authority by which you can get a federal right-of-way. FLPMA also allows federal rights-of-way, and courts have distinguished which authority should apply based on whether the CO2 is natural or is artificial, with natural CO2 coming under the MLA, artificial CO2 coming under FLPMA. So they're serving different functions, and as you can imagine, when you try to think about anthropogenic sources like CO2 that has been separated out from natural gas that was produced or has been captured off of an ethanol facility, is that natural or is that artificial? That judicial distinction, I think, is very difficult to apply in the context of anthropogenic projects. So a lot of different ways that could order some form of open access under state or federal law, but they're all addressing different things. So state condemnation laws are really concerned with assuring that there's public use and that you're not granting condemnation rights and giving property from one private party to another for private use. The Interstate Commerce Act is much more focused on preventing monopolization and encouraging free flow of goods in commerce and preventing discrimination among service providers that are choosing to offer services for hire. And then the Mineral Leasing Act is focused on encouraging efficient use and production of resources. In my last minute or so, I'm going to quickly cover what might happen if none of these apply and you're still denied service. It's possible that you could bring a claim under the Sherman Act to force access to those pipelines as an essential facility. So the essentials facility doctrine, which comes under Section 2 of the Sherman Act, really looks at where you have control of a facility that can't easily be duplicated, that could be provided, access could be provided, but it's being denied to a competitor. The main case, or sort of the seminal case on that, is United States versus Terminal Railroad Association. And I wanted to point out some of the language in the opinion here, because I do think you can see how it would naturally apply, where they say other companies use the terminal properties because they can't acquire other facilities. So there is this compulsion in it because cost to any company is prohibitive. And so they said if we required all these different companies to build their own railroad tracks, it would have this enormous economic expense, but then it would also have the social expense of cutting the city to pieces with lines of railroad intersecting it in every direction, creating a large public burden. There are some challenges that need to be addressed where you do force access, largely, I think, because of those issues that both Maddie and Scarlett mentioned related to impurities, and so as well as some pragmatic things. CO2 streams don't decline in the same way that natural gas or oil production will, so how do you make availability over? If you were to apportion streams in the way that you do sometimes in other resources, it would require point sources to vent CO2. If there wasn't enough capacity, that clearly doesn't make sense and would be out of alignment with tax credit provisions that only allow recovery for 12 years. Tariffs would really have to address liability and purity standards as part of that. Making sure that there's financing really to build up this capacity. And then there could be some issues with commingling, where you have some anthropogenic sources, some natural sources, and that those are then being delivered either for EOR or for geologic storage. I believe you can handle that through contracts between your storage operator and your emitter, but I think that just requires some consideration, and that it wouldn't make sense to writ large apply the model that's used, for example, for oil pipelines to CO2 pipelines, because they are different resources with different considerations. So that's it. We didn't leave any time for questions, and I really apologize. Please feel free, though, to follow up with any of us by email, and we'd be happy to continue the conversation offline.